very interesting set of observations. Mr. Indra Kumar, my apologies. We are running a little bit over time, and we have one more panel after this. So I'm sorry I had to intervene. But just reflecting on the panel and their presentations, Justice Chauhan set us up by thinking of principles of natural justice, first from, and as he said, from a perspective of history and from texts like Antigone, and then thinking of what is at the core of natural justice, and how should we think about the task of a judge or a judicial member or an administrative member on a tribunal. And he also shared with us some examples which allowed us to get a sense of where the concrete principles might come in consideration. Suchindran's talk took us through his experience and of working with Mr. Datar, who has, as you said, crusade is a good term because he's doggedly pursued this question of tribunalization and in some ways also gone back to those ideas of how do you keep principles of rule of law at the core of whatever judicial function is adjudicated. I mean, my one critique of Mr. Datar's point was that in today's system, clearly, even the ordinary courts are not exemplars of those values. And I think he would concede as much, but he said that the answer cannot be that we detract from that and those principles in trying to provide justice. Mr. Indra Kumar took us through actually some of those judgments that Suchindran has been describing. I think he read relevant parts of the NTT judgment in particular and the NCLT judgments. So as a collective, we have different perspectives on what it means to uphold the rule of law. As we saw in the first Q&A, we have a very diverse group of people in the room, and I would request you now to raise your questions or comments. Please begin by introducing yourself so we get a sense of what where you're coming from on the question. And I would request you, if you could broadly, I mean, this categorization can sometimes be a little artificial, but I think in the interest of having a focused discussion, I would request you to stick to the theme of this panel in particular, which is rule of law, natural justice, and procedural fairness. Yes.
Thanks, Arun. My name is Pratik Datta. I work for a think tank in Delhi. My question is to Justice Chauhan. So I think in the first panel, the discussion was broadly across the members. There was a consensus that in India, the laws are fine, the institutions are fine. We just need to get some better people to man these institutions. To which I think Sudhir kind of took an objection and said that maybe we need to also question the laws and institutions. So in that context, you mentioned that there are mainly two problems as far as natural justice, the concept getting implemented. What are the hurdles that are coming up? One is that the executive mindset, which is trained in the executive way, does not appreciate the concept of natural justice, which is a very judicial concept, can be appreciated by a judicial mindset. And therefore, the lack of training. The second argument that you made was the having targets, that if you put target on a judicial officer, that might lead to a problem. But sir, do you think there's a third problem? The third problem being the legal drafting itself. For example, you started off by saying that natural justice as a concept is 3,000-year-old. But yet you had to spend 15 minutes before this august audience explaining what is natural justice. So if in the law you are writing, and we must remind everyone that law is not only for the consumption of the judges and the lawyers. Laws are meant for being consumed by the bureaucrats, who, as we agree, are not legally trained. Therefore, if the law mentions that the bureaucrats are to abide by natural justice, that doesn't give any direction to them. So that means the laws are badly drafted, keeping in mind the fact that the consumers of the law would not be legally trained. Therefore, the problem is not just with the targets and trainings, it's about legislative drafting. So, I would request your reactions to that. Thank you.
To answer your query, yes and no, for two reasons. Number one, when we talk about a language of any field, not just law, but any field, one has to be aware of the idiom, the vocabulary of that field. For example, when you go to talk to a doctor, he says you have such and such and such and such thing. Now you don't understand what disease he is talking about. Which part of my body is he talking about? You say, wait a minute, come down to my level. Similarly, when we talk about law, law has its own idioms, its own terminology, its own way of thinking. That is part number one. Part number two. Recently, when my son was studying some provision, he said, why is it so complicated? It doesn't make any sense. I said, now just wait a minute. Cut it off into segments. When law is drafted, it is not drafted in WhatsApp language, and it can't be drafted in a WhatsApp language. It has to anticipate the future possibilities. Therefore, you will find many of the provisions deal with the past, the present, and the future. Therefore, it may, to an uninitiated mind, it may look a complicated sentence, but to a trained mind, we realize, okay, this is the past that it's talking about, that this has happened, this is happening, and this could happen. Therefore, yes, you're right that initially, prima facie it seems, and again, this term prima facie is also a legal term. On the face of it, it does seem that the language is convoluted and rather confusing. That is one part of it. The other part, yes, the level of drafting in India has come down because we are no longer that familiar with the English language. We do not know the nuances of the English language. We are not familiar with the English grammar. We're not, in fact, familiar even with the punctuation. So many times while sitting in the court, I find the punctuation is wrong. But because the punctuation is wrong, the entire meaning is wrong. So yes, there is a complication. But to say that people ought to be trained, I agree with you on that account. And I'll give you an example. When I became a judge, an American friend of mine, she asked me, she said, all your life you were a lawyer. Today you're a judge. How do you write your judgment? The only answer I could come up was to say that, well, the high court judges are divinely inspired. So when we write, we are all divinely inspired. That made me think, yes, you're right. We need to be taught how to write our judgments. And this is, I say, not only for the non-judicial members or for the technical members of the tribunals. I say this even for a high court judge. We need to know when you talk about a recent decision, what are the elements of a recent decisions? For example, I find in most of the judgments which are now coming before me, people tend to fairly well narrate the facts of the case. People even tend to narrate the contentions. However, when it comes to the reasoning part, where they would reveal their mind, they stumble. Instead of giving me a reasoning that this is the contention, this is the reason why I agree with this plea raised by either the department or the private party, these are my reasons for coming to this conclusion. They find it a lot easier, the tribunal members find it a lot easier just to jump to the conclusion. By jumping to the conclusion, you're not telling me anything. You're not giving me the reasoning behind your conclusion. That is part number one. Part number two, something that Justice R.M. Lodha had the privilege of sitting with his lordship as a junior member of the bench in Rajasthan. He said something which made so much of sense to me. I was dictating a judgment and he said, wait a minute. You're showing your reasoning for the party that is winning. And I said, yes, sir, of course. The moment I start veering towards a particular point of view, towards a particular party, naturally I will talk about their contention. And then he warned me, he said, no. The party that is winning this case is not going to appeal before the Honorable Supreme Court. It's the party which is losing. Therefore, please deal with all the contentions of the party against whom your judgment is going. That is the party that is going into appeal. And it suddenly made sense. I said, yes, that's right. Although my heart and part of my brain might be to the party that is going to win the case. But the fact is I must justify why I do not agree with the contention of the party against whom I am going. Number three, he also said there are ways of tying down the appellate authority. And the ways to tie down any appellate authority is to give 4 or 5 judgments of your own High Court, 2 or 3 judgments of the Honorable Supreme Court. The appellate authority neither would have the time nor the inclination to upset your judgments. These are the secrets that I had the privilege of being handed down by a former Chief Justice of India, something that I like to follow even in my judgments, just to fortify my judgments so that they are not subjected to any being upset by an appellate authority. So you're right that yes, legal language does come in the way. You're right that there's a lack of training, but this is why we are sitting here brainstorming how do you fortify the entire tribunal system.
Thank you.
I'm Mr. Upadhyay, President, Gujarat State Cooperative Tribunal. There is a controversy regarding applicability of Civil Procedure Code and Evidence Act in tribunals. Generally says that CPC is applicable, but preliminary points cannot be decided by tribunals. Order 7, Rule 11, not applicable for tribunals. Even for our board of nominee, they have no powers because CPC, Civil Procedure Code is not applicable. Then if in our provisions say the Civil Procedure Code as far as practicable is applicable, but if wrong suit is filed, the preliminary issue cannot be decided by tribunals or board of nominee. That is my question.
No, in Catino cases, the Honorable Supreme Court has already said that the technicalities and the elaborate procedures of CPC are certainly not applicable. Similarly, the rules of evidence are not to be followed in letter. Basically, broadly, what we are saying to the tribunal is that please keep in mind the procedural fairness, number one. Number two, the third principle of natural justice, that you must give reasoned order. The ultimate goal of any educatory process ultimately is that the person who has come before us must go with the feeling this justice has been done. That is why the Britishers always said it's not sufficient that you're required to do justice, but the justice must appear to be done. Therefore, follow a procedure which is A, simple, not too complicated, B, that will give him the feeling that, yes, I have been heard thoroughly, all my contentions pleased, discussed, debated, argued, appreciated, and yet disagreed with by the presiding officers. That is all that is required. And once you give a reasoned decision, it makes our life a lot easier while sitting at the appellate stage, because we know exactly why you have tilted in a particular manner, in a particular case, towards a particular position.
I'm Khazi Nafiza, sir, Registrar, Karnataka Appellate Tribunal. Isn't this very vague, sir, principles of natural justice? Doesn't this give too much discretion to the judges? Why shouldn't they be codified as Principle 1, Principle 2, Principle 3, and a set be made definite, sir?
Madam, principles of natural justice are embedded in every system. And natural justice need not be codified in a particular manner. It depends upon the facts of the case and the controversy that has which has arisen. And also, the opportunity is that it is first, it should emanate from the person who is seeking to take action. When he when he confronts when he has to take action against another person, when he has to pass an order against another person, or when the court has to take up a particular position, it has to apprise. There, the natural justice starts, charity begins at home. And natural justice should begin from the authority who is seeking to take up a certain action or taking certain pass an order. There it should natural justice is there. And there is no, it cannot be put in a straitjacket formula. it cannot be made. Therefore, it depends on the facts of the case and the failure of the authority.
That gives too much discretion, sir. to
No.
So if it is like at least one or two, if you set it down, somewhere you give it some statutory force. Like principal justice, you may either take note of it or you may not take note of it.
In the forenoon session, somebody pointed out, invariably, in each provision, whatever, it will be said that no action before taking action, opportunity before death. Supreme Court has gone to the extent of saying, if you are taking up an action which results in an adverse order against other party, you are bound to give the opportunity, you are bound to give an opportunity to hear him, despite the absence of any provision to that effect. When this is the law laid down by the Apex Court, to codify that one, here it is to be catalogued, the instances of where opportunity that may not be possible to, that may not be implemented.
Let me also put it this way. You're not right in saying that it's always left to the discretion, because there are plenty of statute. For example, Section 39 of the Karnataka VAT Act, it says, when the assessing officer has reason to believe, therefore he must state on what basis he has a reason to believe that a reassessment is required. Number two, it clearly says you must give notice. So the statement of a reason for your conclusion is there. The fact that you're being told, please, prior to passing your demand notice, prior to passing your assessment order, please give notice to the other party. Now, naturally, giving a notice to other party is not a customary act to be performed. It must have some substance behind it. And why are you calling that party? Without saying so explicitly, what we mean to say is, please give him an opportunity of hearing. Now, that is one part of it. The other part of it, please remember that law in itself has to have a discretionary aspect left to the judges. And I'll give you an example. In America, what they have done is they have something called sentencing policy, where given a given fact, everyone is told you must sentence the person for 7 years, for 10 years, for life. Now, unfortunately, that is creating a lot of problems, because every case has its own peculiar facts and circumstances. Now they're realizing after 10 years of sentencing policy that, oh my God, we made a mistake. The same mistake, now they seem to be realizing, oh my God, we elected President Trump. But now it's too late. Now hopefully they're at least repeal their sentencing policy, because they're realizing 3 convictions and you're in for life imprisonment, no matter what your offense is. Therefore, it is a dangerous signal within any judicial system to have too much of straitjacket formula. It is better to leave the judicial system with a sense of flexibility. That's why you would realize that in a case like Keshavanand Bharati, they have really not pinpointed all the basic structures. They said these are only illustrative, because every generation will have to decide what according to it is going to be the basic structure. The Supreme Court would have done us a great disfavor if they had named and said, these are it. For future, no more addition to this list. That can't be. We have to have that flexibility. As an administrator says, please give me the flexibility at the joints to take my own decision. So the judiciary, whether it is a part of tribunal, a quasi-judicial body, or a judicial body, would also require a certain discretion to be left to itself.
I'm John Benedict from E-Governance Department, Lordship. So I've been working on this e-courts and the process reading part of it. So this question is on procedural fairness. Working on all this from the filing till the disposal in the appellate tribunal, in the High Court and the other courts, I found that in the name of a procedure, sometimes the justice gets delayed. I found that there is no clear set of guidelines or regulations. For example, the party didn't appear, or the records not received. All these things goes for if any case which is more than 3 years or 5 years in any court. So we found that 80% time is on the registry, or that the work to be done on that. And to make it very clear, Lordship, I believe if the procedures are made clear with a set of guidelines, that will deliver more natural justice. So what is your point on that, Lordship?
I'm in 100% agreement with you. I find the procedures here, in fact, what I call the great fishing net that we all spread, called procedure. Unfortunately, there's a difference in thinking. And again, I go to the fact that there are different mindsets. If you read the Western mind, the American or the English, you'll find that their underlying theory is, and philosophy is, let us simplify everything as much as we can for the benefit of the people at large. Unfortunately, in India, we have just the converse thinking. Let's complicate everything as much as we can for the non-benefit and to harass the common man. Because it's only after harassing him that he will come to us and beg for mercy. When he begs for mercy, we will have the right to demand certain things from him, which may be extra legal. Therefore, we delight ourselves in creating as many procedures as possible. I am thorough agreement with you. A, please simplify your procedures. Make your procedures known to the people. In fact, one thing that I find horrifying as a lawyer was when I went to first time to the registry, is the elaborate procedure of the registry. Just to get one file passed in the High Court may take you 2 to 3 days. Now, if there's a dire urgency, there's nothing I can do for my client. Now, there's no reason why the filing of the case, the passing of a case, for example, even in Karnataka, I find it amazing. We claim to be sitting in the Silicon Valley, and yet in the High Court of Karnataka, the cause list is received by all of us the night before the next date. Yes. Now, to me, that is amazing. I see no reason why our cause list can't be made 3 days or 5 days ahead. Now, it is the procedure that is creating us and preventing us from delivering our justice as soon as possible. That's one of the major flaws, but unfortunately, we are too bothered about the petty aspect whether Ram Mandir is going to be built or not. So,
I'll have to keep time and play my role as timekeeper. May I request you to please hold your questions and talk to the panelists over tea. We have one more panel to get to after this. So Ms. Nafisa, may I ask you to do the host duties and resume?
For kind attention.
Sorry.
Kind attention.
Sir, excuse me, sir. We'll have to hold this question, please. We have to end the session. May I request you to speak to the panelists in the tea session?
Kind attention, please.
Thank you. Ms. Nafisa is going to present a token of appreciation.